This is Bloomberg Law with June Grasso from Bloomberg Radio.
The Supreme Court justices clashed today over the limits on a state's power to ban abortions when a woman's health is in jeopardy. It indicates a deep divide over the Biden administration's attempt to protect access to abortion in medical emergencies, even in states like Idaho with near total bans on abortion. During the tense arguments, the court's 3 liberal justices agreed with the administration's view that a 40-year-old federal law, EMTALA, requires hospitals to provide abortions when necessary to prevent major health consequences for the woman. Here's Justice Elena Kagan.
Where the woman is, her life is not in peril, but she's going to lose her reproductive organs. She's going to lose the ability to have children in the future, unless an abortion takes place. Now, that's the category of cases in which EMTALA says, my gosh, of course the abortion is necessary to assure that no material deterioration occurs. And yet Idaho says, sorry, no abortion here. And the result is that these patients are now helicoptered out of state.
But the court's most conservative justices, like Samuel Alito, question the administration's reading of the law.
How can you impose restrictions on what Idaho can criminalize simply because hospitals in Idaho have chosen to participate in Medicare? I don't understand how this squares with the whole theory of the spending clause.
It's the first time the court has reviewed a state abortion ban since it overturned the right to abortion in 2022. Joining me is Elizabeth Sepper, a professor at the University of Texas Law School. Liz, there was a lot going on under the surface of these arguments, but tell us about the main issue.
The main issue is whether emergency department physicians in Idaho have to comply with the Federal Emergency Medical Treatment and Labor Act, or if the state law that only allows them to provide abortion if someone's life is at risk is what governs their provision of emergency medical care.
So the Biden administration maintains that Idaho's law, it collides with the federal law, EMTALA, and so should override Idaho's ban. That's federal preemption. Why doesn't that answer the question here?
Yeah, that should answer the question. The U.S. Constitution has a supremacy clause that says federal law is supreme and EMTALA is federal law. There are questions about the degree of conflict between Idaho's abortion ban with its very narrow life-saving exception and EMTALA. Idaho, at multiple points, tried to claim that there actually was no conflict between state law and federal law at all.
That was surprising to me, and I think it was surprising to some of the justices as well. They asked, well, why are you here if there's no conflict?
Right. It would seem that if there is no conflict, we should both see emergency department doctors able to provide the same emergency abortion care they were providing pre-state law ban on abortion. And also it would seem like the state shouldn't be at the Supreme Court on this question. I think Justice Jackson, though, really put her finger on the issue. The state of Idaho was trying to argue there wasn't a conflict with federal law by saying that the federal law essentially defers to state law on the question of what medically appropriate care is in an emergency. And so that if someone complies with a state law, they are automatically complying with the federal EMTALA. And she pushed the Assistant Solicitor General from Idaho whether it would be true that if a doctor complied with EMTALA, that there would be no conflict with Idaho law.
And what was his response?
I don't think that he could really respond in a satisfying way, right? She said, well, if there would be no conflict, why not let doctors comply with EMTALA? And the state law presumably allows them to do so if there truly is no conflict.
Particularly the Solicitor General pointed out what's happening on the ground, so to speak, saying that Idaho's abortion ban has already affected emergency care, that women are being flown to other states.
Yeah, I think the Solicitor General really focused the court on what is going on in Idaho. It's one thing to claim that you could read the statutes as having identical requirements for emergency care. It's quite another to look at Idaho and see what has happened under the abortion ban. And what has happened is there are hospital closures. There is near impossibility in recruiting OBGYNs to come to the state. And people who become pregnant are told to purchase insurance for medevac flights, because what physicians know is if they experience complications in pregnancy, those pregnant patients are going to need to be dumped on another state entirely.
Under Idaho's law, abortions are only allowed when necessary to prevent the death of the pregnant woman. So Justice Sotomayor asked Idaho's lawyer if it were true that the state's ban would prevent abortion in situations where a woman would otherwise lose an organ or have serious medical complications. Justice Kagan brought this up as well. And when pushed, Idaho's lawyer said, yes, abortions are, in that case, are not allowed.
Yeah, there was some slipperiness, though, I think it seemed, in the answers to, I think, really concrete clinical cases that the justices were presenting to Idaho's Assistant Solicitor General. And, you know, many times what he would come back to is, well, if there's good faith medical judgment, and they had to keep pushing him on good faith medical judgment of what? And the answer under Idaho law has to be that death is likely to occur.
Did he ever admit that, you know, it would have to be that radical for an abortion to take place?
No, we got the same sort of rigmarole that we get whenever health and life exceptions come up, where the defenses of these really narrow exceptions tends to pass the buck to physicians to say, well, they can go ahead and exercise their medical judgment, and surely there doesn't need to be imminence here. It could be something that could occur the next day or within the week. It doesn't have to be imminent. The Solicitor General said, look, it says necessary, right? Even if there's not an imminence, this will occur within minutes, the necessary to prevent death does tell you something about the connection between performing an abortion and avoidance of death. You have to be able to establish that it was necessary. And if a doctor does perform an abortion under these circumstances, they always face the possibility that an enterprising prosecutor could come along and second-guess their medical judgment.
And under this law, performing an abortion outside of these limited exceptions is a felony punishable by up to 5 years in prison, so a tough penalty. So the three liberal justices seem to be firmly on the Biden administration's side. So let's turn now to the conservatives, starting with Justice Samuel Alito, who wrote the majority decision overturning Roe, and he seemed to be most invested in supporting Idaho's law. He grilled the Solicitor General about whether mental health is a condition that would require abortions. He also pointed to language in EMTALA that refers to unborn child.
So in that situation, the hospital must stabilize the threat to the unborn child.
Yes, it was relatively unsurprising that Justice Alito was the one to latch on to the language of unborn child within EMTALA. Now, we've been told that everyone is now a textualist, that we look at the statute's text and that pretty much ends the discussion about what it requires. EMTALA's text is actually quite clear. Only an individual can have an emergency medical condition, and an individual has to be someone who is born. And so a fetus is not someone who is born. Now, there was language related to unborn child added to EMTALA to reflect the fact that for a pregnant person, that individual could be in an emergency scenario if her own health were in jeopardy or if the fetus's health was in jeopardy, really affirming that emergency departments need to screen pregnant people not only for the stability of their own health, but to make sure the fetus isn't in distress.
Which of the conservatives were, like Alito, seeming to be supporting Idaho's law?
Justice Gorsuch spoke out quite a bit in ways that indicated affinity for Idaho's position. Justice Kavanaugh had an extended exchange with Idaho over the question of whether there was a conflict at all between Idaho law and federal law, seemingly leaning very strongly toward the view that there was no conflict between the two. Justice Barrett asked a sort of wide range of questions. I've read a number of commentators now who suggest that her vote could be in question, or perhaps that she was sympathetic to the position of the United States. I think that's highly unlikely, just given the reality of who Justice Barrett is. And I think often her questions in oral argument are not particularly indicative of what her vote will ultimately be in the case.
So that makes 5 votes in favor of Idaho's ban on abortion, because we know where Justice Clarence Thomas stands.
It's hard for me to imagine, that was my view going in, that the Supreme Court doesn't want to get it to 5. I think there are really open questions after the oral argument as to how it would get to 5, on what particular facet or facets of this litigation. You know, we saw at least 3 justices sort of play with the notion that maybe spending clause legislation can't impose these kind of substantive obligations, which would be sort of a far-reaching deregulatory sort of analysis. We saw Justice Thomas start off with that argument. And then, of course, we have, Justice Kavanaugh really pressing the idea that there might not be a conflict between Idaho law and EMTALA, but presumably buying into Idaho's argument that as long as you comply with state criminal law, EMTALA won't require you to do more, that there's baked into the federal law the incorporation of state criminal law.
Could you tell where the Chief Justice was?
The Chief Justice said very little in the oral argument, so I don't think he revealed much about where he was.
Coming up next on the Bloomberg Law Show, I'll continue this conversation with Professor Elizabeth Sepper of the University of Texas Law School. Just how tense were the arguments? It seemed like even the patience of the Solicitor General was tested. I'm June Grasso, and you're listening to Bloomberg. A case at the Supreme Court today pits Idaho's near-total ban on abortion against a federal law that requires hospitals to provide emergency health care. Ahead of the arguments, abortion rights advocates were concerned that the case might be used to advance the fight for fetal personhood, the idea that a fetus would have the same rights as the pregnant woman. And Justice Samuel Alito, who wrote the decision overturning the right to abortion, sharply questioned the Solicitor General, Elizabeth Prelogar, about his interpretation that the federal law imposes an equal duty on the hospital to both the pregnant woman and the fetus, whom he referred to as the unborn child. But the Solicitor General pushed back forcefully.
So in that situation, the hospital must stabilize the threat to the unborn child. And it seems that the plain meaning is that the hospital must try to eliminate any immediate threat to the child. But performing an abortion is antithetical to that duty.
That stabilization obligation equally runs to her and makes clear that the hospital has to give her necessary stabilizing treatment. And in many of the cases you're thinking about, there is no possible way to stabilize the unborn child because the fetus is sufficiently before viability that it's inevitable that the pregnancy is going to be lost. But Idaho would deny women treatment in that circumstance, even though it's senseless.
I've been talking to Professor Elizabeth Sepper of the University of Texas Law School. So did it seem as if the Solicitor General, who is the consummate professional and excellent in handling questions at these arguments, that she seemed to be losing patience or frustrated a few times with the conservatives' questions, particularly Justice Alito?
I mean, I think an important thing to note about oral argument is it's not just an opportunity to convince the justices. It's an opportunity to speak to the American people, and I think we saw the Solicitor General doing that in multiple places. I think how she began her argument by bringing the justices and the conversation back to the experience of people on the ground in Idaho who are being denied health-saving pregnancy and abortion care was one moment. But I think another moment was her interchange with Justice Alito at the end, where he really was suggesting that physicians need to save the unborn child, and that's what federal law requires. And she really pushed back that the individual in EMTALA is the woman, and that in some scenarios what we're really talking about, and the very premise of his question, he said, is that the pregnant person does not get treatment to save her health, her organs for life. And I thought that was, meant more for us than it was to persuade Justice Alito, who the Biden administration knows is unpersuadable in this case and many others.
When you hear what the situation is in Idaho now, what's happening, and in other states that have these near total bans, it's hard to imagine the Supreme Court doing what it's likely to do, which is uphold this Idaho law when, women's health is in jeopardy here.
Yeah, and EMTALA matters quite a bit to a narrow range of situations, to crisis situations. But those situations, of course, are really life or health on the one side for people who are experiencing them. And I think in red states or states that have abortion bans in place, EMTALA is what is left of protections for miscarriage management and for abortion care in these crisis scenarios where someone's being made quite sick from their pregnancies. So it matters quite a bit under abortion bans, not just about Idaho, it's about every state that has an abortion ban that prohibits emergency abortion care in scenarios where EMTALA would require that care be offered to a pregnant person. It might matter to states that have more liberal abortion policies as well, and this is a real concern. How the court decides this case could have real implications beyond states with abortion bans. If you read the amicus brief, if you read the brief from the state of Idaho, there's actually an argument being made that fetuses have equal rights to pregnant people under federal law. And if that's right, and a number of amicus briefs go this far, then it is actually prohibited by EMTALA for a hospital to perform an abortion. And that's federal law. That would be the rule everywhere. New York, California, Rhode Island.
Do you think the conservative justices would go so far as to embrace this idea of fetal personhood?
It would not surprise me to see a concurrence that makes the argument for statutory fetal personhood. That is, that with this 1989 amendment to EMTALA that added the language of unborn child, in order to emphasize the dual obligation to the pregnant person, that in fact EMTALA creates an obligation to the fetus that's equal to the obligation to the pregnant person. I don't think that we're going to have a majority of the court that would be willing to go along with that, probably, but we could easily see a concurrence that begins to build fetal rights under federal statute.
So the decision here, will it have definite implications for states that have enacted these near total bans on abortion?
Yes, absolutely. So the court could side with the Biden administration. If it sides with the Biden administration, then EMTALA preempts conflicting state laws. So to the extent a state abortion ban conflicts with EMTALA, EMTALA applies, and emergency departments, physicians would be free to provide abortion care consistent with EMTALA. If the court sides with the state of Idaho, under virtually any rationale it might decide the opinion, that will also affect other state laws because the Idaho law is quite extreme. It has a very narrow exception only for life. So if there's no conflict between the Idaho law and the federal EMTALA, then there's no conflict between EMTALA and Texas law, for example, which has a life as well as a substantial impairment of a major bodily function exemption. Or perhaps even more worryingly, if the idea is that EMTALA incorporates state law by reference, so the standard of care is set by state law rather than national medical practice, then I think that application could apply beyond abortion to other sort of hot areas where, in particular, Republican legislatures are trying to regulate medical care and restrict medical care.
Let's say there are 5 votes to support Idaho's abortion ban. Does the court then tell the Biden administration, you can't enforce EMTALA in this way?
The idea would be simply that EMTALA doesn't apply as the Biden administration has said it applies, right? So the rationale could be that EMTALA only requires stabilizing treatment consistent with state criminal law or state law, period. That's one of the lines that Idaho is pushing. So if that's the notion, then state law is really the baseline, not so much EMTALA.
What does it indicate that the Supreme Court allowed the Idaho law to take effect while they're hearing the case, and also that they took the step, unusual, of bypassing the federal appeals court level and, deciding to directly review a federal trial court's ruling.
Yeah, I mean, it's a sign of where they are headed and where they want to head fast. And, they're abundantly aware, too, that they have a cert petition currently pending from the Biden administration involving a very similar case out of Texas. It really raises that question squarely about the interaction between state law and the federal EMTALA.
Does it seem clear that the justices, and particularly Samuel Alito, who wrote the decision overturning Roe, were wrong in thinking that they were done dealing with abortion cases by putting it in the hands of the states?
Yeah, the court has 2 abortion cases less than 2 years after they overturned Roe v. Wade. And this is clearly an issue that the justices are going to see over and over again with regard to EMTALA, with regard to FDA, with regard to constitutional arguments related to a right to travel. And so I think they will be regularly adjudicating cases involving abortion. And that's really a legal landscape that the Supreme Court created itself.
And will you explain the arguments around federal conscience protections?
One theme in the oral argument on EMTALA were federal conscience protections. And these came up with regard to the abortion pills oral argument as well. And I think we see some concerning developments here with regard to conscience protection. So conscience protections are just the idea reflected in federal and state law usually that people with religious or moral objections to performing abortions can't be discriminated against, usually can't be required to perform abortions. This is fair enough. The issue here, though, involves the interaction between emergency medicine and conscience protections. And we got some very, very disturbing statements, I think, from the U.S. government as to the position of the U.S. government on these laws. The U.S. government is now arguing that federal conscience protections allow not just individual doctors, but entire institutions not to provide emergency abortion care. This is shocking. This is shocking because with the Affordable Care Act, there were lots of debates over this issue. It was the position of everyone, the United States government included, that in emergency scenarios, there was no right to say, my moral feelings would be hurt by this, and as a result, you get to lose your kidney. This was not a viable argument. How do I know that's true? Because multiple times Republicans in Congress tried to amend the law to allow exactly this to happen, to create a conscience exemption related to EMTALA. They failed each time. And now we see the U.S. government showing up in the Supreme Court and in 2 arguments claiming that this right exists. It's a real problem because I think it opens the door to religious institutions, and there are many in healthcare, to denying emergency abortion care, including in states where abortions are legal and readily available. And that is really seriously concerning because it goes much farther than even what, say, the U.S. Conference of Catholic Bishops were arguing some 20 years ago. It goes farther than what the Catholic Health Association has said is required. And so I think we're in a brave new world with regard to the invocation of conscience constantly, regardless of the cost for human health or human life.
And that's something you don't hear talked about as much as apparently we should be talking about it. Thanks so much, Liz. That's Professor Elizabeth Sepper of the University of Texas Law School. Coming up next on the Bloomberg Law Show, the Chamber of Commerce is already suing to block the FTC's newly announced non-compete ban. I'm June Grasso, and you're listening to Bloomberg. Business groups led by the U.S. Chamber of Commerce sued the Federal Trade Commission today to try to block a rule finalized this week that would outlaw non-competes. Those are provisions that prohibit workers from switching jobs within an industry. The Chamber argued that the FTC lacks the authority to issue rules that define unfair methods of competition. The regulator has argued that its legal authority is crystal clear in the FTC Act. Joining me is Bloomberg reporter Leah Nylen. Leah, let's start with the FTC's ban on non-competes. Tell us about it.
Yeah, so the FTC voted to adopt what's a nearly complete ban on non-competes going forward. So after the rule after the rule goes into effect, there will be no more non-competes, which are essentially just clauses in employee contracts that forbid them from switching jobs within an industry. There's a couple tiny carve-outs. One, if you are an executive who is currently subject to a non-compete, and they define an executive as somebody who makes more than $150,000 per year and has a policy position within your organization, you can still be subject to your current non-compete, but executives going forward cannot enter into new ones. And the other sort of tiny caveat they made is if you are selling a business, you can be subject to a non-compete because they're trying to prevent essentially, a thing where somebody who is a startup founder or something sells their business to someone and then goes out the next day and starts the same business under a different name. Businesses do want a little bit of comfort that when they buy something, they are getting all of the assets and sort of knowledge there.
Many people still think of non-competes as being for executives, people with trade secrets, but nowadays they even apply to blue-collar workers and minimum wage workers.
Yes, the FTC started this initiative a couple years ago. They started it with a workshop in which they had academics who had studied this come in. And they also had some state lawmakers, because before now, non-competes were largely regulated at the state industry. And it was actually a pretty interesting workshop that happened during the Trump administration. The attorneys general from Illinois and a couple other states had come and talked about how they had found that there were a weird proliferation of these in a lot of, as you mentioned, minimum wage jobs. There ended up being a pretty famous one involving the sandwich chain Jimmy John's, in which it was trying to prevent its sandwich makers from going anywhere else that made sandwiches. And they had a pretty detailed list of things that they couldn't do, including making pitas or making hoagies. All of these different types of sandwiches, you couldn't go somewhere else that made them. They found out in Washington State people were doing it at coffee shops. They didn't want baristas moving around. It's fairly common among hairdressers. So, yes, while it's sort of associated with executives and very well-compensated employees, it had really proliferated around the economy to a lot of lower wage jobs and even some that you might be surprised by, like doctors and nurses were often being asked to sign non-competes.
Well, sandwich makers also surprises me. So, getting a ban like this, President Biden directed the FTC to get a ban like this more than 2 years ago, so high priority for the administration?
Yes, Joe Biden signed this executive order his first year, the executive order on competition, and he actually says in some of his public speaking that the thing that first made him very interested in the issue of competition was when he was on the campaign trail during the last election and hearing from a number of workers who had mentioned to him non-competes. And that really sort of struck him as wrong. Non-competes are very a fundamental restraint of trade, as people say. It is literally preventing a worker from going out and trying to get a better job that pays them well. And particularly when you have, people who have skills that require some kind of licensing within a state, even medical or even hairdressers, when you move, if you try and move out of state to get another job, you have to go through the process of getting your recertification. It's very expensive. So these non-competes can have a pretty serious impact on people's everyday lives when you really can't go and work for a competitor. So,
but this was a narrow 3-2 vote? It went down party lines?
Yes. So the FTC is a 5-member body. It has 3 Democrats right now because the Democrats are in the majority, and then 2 Republicans. And they did vote along party lines. Both of the Republicans, in their votes, they gave public statements about them during the Open Commission meeting earlier this week. And they said that while they sort of agree in principle that non-competes are problematic, they are concerned that the FTC does not have the authority to issue this type of rule. And that is what various lawsuits that have now been filed challenging the rule have also said, because there is a little bit of a question about whether the FTC statute as written would allow them to have this rule.
So the Chamber of Commerce, the nation's largest business lobby, is one of those suing. Is that what they're alleging, that the FTC just doesn't have the authority here?
Yes, they have two major arguments. The first being the FTC does not have the authority to issue this type of rule. So the FTC says it does because the FTC Act allows them to prohibit what are known as unfair methods of competition. And so in the rule, they said this is an unfair method of competition. And the FTC Act also has another section that says that they are allowed to issue rules and regulations to help enforce the law. So to the Democrats on the FTC, they think that makes it pretty clear that they are allowed to issue a rule of this type. The Republicans say, historically the FTC has prohibited unfair methods of competition by individual enforcement actions. And very rarely has it actually gone through with a rulemaking. The last time they had a rulemaking that used this unfair methods of competition statute on its own to make a rule was something like the 1970s. And generally, they make rules under some of their other authorities. So that is like one half of the Chamber of Commerce's lawsuit. The other half is, the Supreme Court in a case recently said that they have concerns when agencies act on major questions. And so the Chamber of Commerce is also sort of challenging the FTC's non-compete ban under this major questions doctrine. That's the idea that if Congress really did want you to solve this major question, they would have been very, very explicit in the statute that this was the sort of action that the agency could take.
And also the Supreme Court, the conservative members of the Supreme Court are on sort of a mission against the administrative state, and there are several cases involving the reach of agency powers. So do people you've talked to think that the chamber has a good case here?
It's pretty much right now falling along party lines. The FTC did have a challenge to its authority to make rules back in the 1970s. That took place here in the D.C. Circuit. That's part of the reason why the chamber opted to sue in Texas, which is in the more conservative Fifth Circuit, because if they had filed here, they would probably refer back to this 1970s case that says, yes, we think the FTC has this authority. But by filing in a new circuit, they can sort of have that circuit take the question up anew, potentially creating a circuit split that they could then take up to the Supreme Court.
And what other groups are suing besides the chamber? So
the Chamber of Commerce and the Business Roundtable are two, alongside some local chambers of commerce in Texas. That's how they got venues in Texas. There was also a tax firm that filed its own lawsuit. We've been getting a couple others as the day has gone on of various people who are filing. When the FTC announced this, there were a bunch of business groups that came out against it, including HR professionals associations, a lot of professional associations like actuaries, things like that came out sort of against the idea of banning non-competes.
It's going to add hundreds of millions of dollars to workers' wages. Is that why business groups are mostly against it, or are there other reasons besides money?
The business groups say that non-compete are useful for sort of protecting business information. So, you don't really want to hire an employee and then have them the next day go across the street to your biggest rival and tell them all of your customers or your business plans and strategy. The FTC says in response, there are all sorts of other laws that you could, use to address that. Trade secret law, non-solicitation clauses, things like that. So you don't really need a non-compete, which effectively bars them from taking another job. The other aspect that the FTC left open in the rule is that you could offer an employee garden leave, is sort of what it's known as, which is where you are requiring them not to take another job for a certain period of time, but you are continuing to pay them either a salary or some sort of compensation to make up for the fact that they can't take this other job. That way, when they go to a new employer, like the information they have about your company is at least a little bit dated.
With the proposed rulemaking, there was a solicitation of public comments. What did they say about the comments that they got?
Yes. So the FTC got 26,000 comments, which is a lot for the FTC. Oftentimes, They put out for public comments and only get a couple hundred. So they were pleasantly surprised that they got 26,000. Of the 26,000, 25,000 were actually in support of the rule, which is one of the things that they cited for a reason why they felt comfortable moving forward with this. And in the rule itself, they cited a bunch of them from individuals who talked about how non-competes had significantly impacted their lives, preventing them from taking, other jobs, or when they did try and take another job, they got sued. As I mentioned before, a lot of non-competes before this rule were really handled on a state-by-state basis. And because of that, you would often have to go to court to see if a non-compete was enforceable or not. And the average person doesn't have a lot of experience with courts or suing over contracts. And so when, an employer might threaten to sue them, that was sometimes enough to keep them from trying to change jobs because they don't really want to have to deal with that.
Does the FTC or the Biden administration expect this to have, a broad effect on the workplace or the workforce?
Yes. So the FTC did some of its own calculations on how broad this might be. They estimated that it would impact wages to the tune of $400 billion over the next 10 years. They also, however, said that they think that it may help with small business formation because when people are no longer subject to a non-compete, they can go out and start their own businesses in the same industry. And so they had some research that they did showing that it would increase new business formation by as much as 2.7% a year. So their findings were largely that this would have a positive impact on the economy.
Thanks so much, Leah. That's Leah Nylen, Bloomberg antitrust reporter. And that's it for this edition of the Bloomberg Law Podcast. Remember, you can always get the latest legal news by subscribing and listening to the show on Apple Podcasts, Spotify, and at Bloomberg.com/podcast/law. I'm June Grasso, and this is Bloomberg.